Hello everyone, this is the video of Legal Studies, Class 12, Unit 2nd, namely Topics of Law, and the topic that I have been discussing from last a few videos, that is Tort Law. And under the Tort Law, I will discuss in this video about the strict liability. So, let's begin with the meaning and concept of a strict liability. In tort law, a strict liability is a form of liability under which a person is legally responsible for the consequences occurred from an activity in which he/she is not involved nor have any bad intent. See how beautiful this sentence is. That saying simply, because of some of your action in which you are not involved, as well as you didn't have any bad intention, but you are remotely or say indirectly related to that incident which causes harm to someone else, you will be responsible for that. Though you didn't do anything, you are sitting calmly, peacefully in your home, but something wrong happened at the remote place, that is maybe your factory, your company, something like that, and that causes harm to some people or someone, then you will be responsible. You can see that you are not involved, you didn't have any bad intention, as you even don't know what happened there, but still you will be responsible. So that is a strict liability. So because of such nature, this strict liability sometimes also known as no fault liability, because you don't have any fault, as you didn't do anything, but still you are liable. So that is strict liability. The strict liability is the imposition of liability on a party or defendant in the absence of fault, such as negligence or tortious intent. As we have discussed in our previous videos, that what are the intentional tort and what is negligence. In both the conditions, person himself or herself physically involved, maybe directly or indirectly, but he or she is involved. But here the person even doesn't know about the incident, even then he or she is liable. Just try to understand what is the difference. So in this case, the claimant only needs to prove that the tort occurred and that the defendant was responsible. So what all you need to do, being a victim or claimant, you need to establish a relationship between your injury and with that person. Maybe, for example, I can say that something wrong happened in A's factory and B got injured. B was passing through that factory and B got injured. Though A is not even in the factory at that point in time, but anything wrong happened in his factory and that causes harm to others, then A will be responsible. Okay, so this is how the concept of a strict liability is defined. But don't worry, in my next slide I will also discuss some of the cases that will further clarify your doubts. Okay, but by the time I believe you must understood the meaning of strict liability. Okay, the next point is, that is, major examples of a strict liability. The first one is product liability. The second one is abnormal dangerous activities. Okay. The third one is intrusion onto another's land by livestock. And the last one is ownership of wild animals. See, there are four examples of strict liability. The product liability, you can say, what does it mean? I just explain it. The product liability means you manufacture certain types of product. Say you manufacture, for example, water, okay, mineral water, and you supply to many people. Sometimes or someday what happened that your mineral water or in the bottle of that mineral water maybe some insects by mistake somehow a person found in the bottle of that mineral water. Okay, though it is the negligent act of your employee, but if there is insect inside a sealed bottle, then it is you being the owner of that factory will be responsible. Okay, so this is product liability. So because of that faulty or polluted water, if someone fallen ill, you have to take care of his all medical expenses and other damages. Okay, so that is product liability. The second one, as you have seen here, that is abnormal dangerous activities. Say it is something like you are running a hazardous factory, hazardous in the sense that some kind of chemicals production and the kind of thing that is going on, some poisonous gas you use in your factory, and somehow that gas got leaked. You are sitting in your home, keep in mind, and that poisonous gas caused harm to people living nearby, maybe your employees as well as some innocent people, they who were living around your factory. So in that condition, again it is you only who is going to be responsible. Okay, so that is abnormal dangerous activities. The third one is intrusion onto another's land by livestock. See, you have certain kinds of livestock that you tamed, and someday maybe say you have certain number of horses, and someday some of the horses got freed, and I don't know how it happened, but somehow those horses entered in others' land and damaged his property. Though you are unaware of this fact, but since all the horses belong to you, so the damages caused by those horses, you will be responsible for that. Okay, so that is intrusion onto another's land by livestock. And the last one, that is ownership of wild animals. This is, I believe you must have understood by the time that if you just taming any wild animals and that affect or harm any person by any means, then of course you are responsible for that. So there are the four types of or four examples of a strict liability. Okay. The next thing that I will discuss, that is case law of a strict liability. See, it is interesting to note that the concept of a strict liability came into picture through the English case, that is Reliance versus Fletcher. It is 19th century case in which House of Lords established a new area of English tort law. What happened in this case? Reliance had employed contractors to build a reservoir. See, it is interesting story. And hence, he was not playing an active role in its construction because he employed certain people or contractors who were doing the work of construction. While construction was in progress, the contractors discovered a series of old coal shafts which was improperly filled with debris. What happened that those lands, I believe, were the part of some coal mines, and coal mines were being done there, but those mines were not filled with the debris or whatever the things that need to be filled after mines is done, but that is not done there. So in spite of knowing this fact, instead of taking any precautionary measure, they chose to continue the construction work in that field, though, as I said, that area was vulnerable because of being so many mines, a series of mines. As a result of this, Reliance Reservoir burst and flooded into neighboring mine run by Fletcher. So nearby Fletcher's mine was there, and since it is burst and flooded, so that affected Fletcher's mine and caused pound 937 worth of damage in 19th century. Remember, Fletcher brought a claim under negligence against Reliance. In this case, though Reliance argued that he is not involved in this damage, as he was not even aware of this incident. But court didn't pay attention on this argument, rather given the concept of a strict liability. Because if you or through your employees you are doing certain kind of things, then it is your duty to take care of the things properly. So if someone else means your employee does something wrong, then you will be responsible for that. So it is a strict liability. Okay, so I believe you must understood the meaning of strict liability and the case, because this is important case. Now the next point is the concept of strict liability in India, which is known as absolute liability. It means instead of a strict liability in India, the concept of absolute liability is used. Okay, so instead of a strict liability, the concept of absolute liability is evolved in India. The advantages of absolute liability over the strict liability is that absolute liability has no limitation. Just pay attention. It means a strict liability has certain number of limitations, but absolute liability has no limitation or exception. Rather, it applies to both on individual as well as on firm, company, etc. The principle of strict liability has certain limitations as discussed and exceptions, as it was not applicable on an individual for his negligence. However, in case of absolute liability, there is as such no exception and limitation. Okay. So the principle of absolute liability in India was laid down by the Honorable Supreme Court in the case of MC Mehta versus Union of India and Bhopal gas leak case. In both the cases, the Supreme Court maximized the limit of the rule set in Reliance versus Fletcher. So now let's check out some cases related to this. Starting with the Bhopal gas leak or Bhopal gas leak disaster case. In the year 1984, what happened that an accident occurred as a result of which the hazardous chemical methyl isocyanate and other toxic gases leaked from the Union Carbide India Limited, located at Bhopal in Madhya Pradesh. The company was the subsidiary of Union Carbide Corporation, a multinational company registered in United States of America. In this incident, more than 2,600 people died instantaneously and lakhs of people were seriously injured. As a result of this, several lawsuits were filed in India as well as in the New York City of United States. Okay, and this case was so prolonged that so many things happened by the time and so many rules are even evolved. Okay, but we will discuss this case in higher class in detail. Okay, now let's check out another case, that is MC Mehta versus Union of India. And this is the case where the concept of absolute liability evolved. On 4th and 5th of December 1985, oleum gas leaked from one of the units of Shriram Foods and Fertilizers Industries located in New Delhi. It was the unit of Delhi Cloth Mill Limited. In this incident, one person died and many others badly affected because of the poisonous gas. So in this case, Supreme Court introduced a new principle, namely absolute liability for the harm caused by dangerous substance. Likewise, while deciding the case, the then Chief Justice of India, P.N. Bhagwati, said that we are of the view that an enterprise which is engaged in a hazardous or inherently dangerous industry, which poses a potentially threat to the health and safety of the persons working in the factory and residing in the surrounding areas, owes an absolute and non-delegable duty to the community to ensure that no harm results to anyone on account of hazardous or inherently dangerous activity in which it is engaged, must be conducted with the highest standards of safety, and if any harm is done on account of such activity, just pay attention. I just repeat, okay? It is engaged must be conducted with the highest standards of safety, and if any harm is done on account of such activity, the enterprise must be absolutely liable to compensate for such harm, and it should be no answer to the enterprise to say that it had taken all reasonable care and that the harm occurred without any negligence on its part. So, duty of care, the concept of some excuses, defense, nothing is there. Absolute means absolute. Okay. So, this is the concept of absolute liability. I believe you must enjoyed this video because this is very nice concept. And the understanding of this concept will help you to understand so many things under the tort law and to claim your right or damages whenever it caused to you or to your any known person. Okay, then see you in next video with some another topic, namely summary of the kinds of harms. Okay.